So Nevada is trying to pass a bill which will allow felons the ability to sue people in civil court who may have harmed them during the felon's commission of a crime by breaking into their home and getting harmed in the process. Okay. Hello everybody, this is Chris with Marksman Shooting Sports in Westfield, Indiana. You are watching Marksman TV and this is Counter Talk. Today we will be discussing the Navada Bill SB254, which is basically attempting to allow felons the right to file a civil liability claim against a homeowner if that felon was harmed by the homeowner during the commission of a crime. This is intended to be an amendment to the current Nevada state your ground laws. Basically, the bill states, removes provision that provides immunity from civil liability and actions involving use of force under certain circumstances, which we need more clarity on. As you can see, this was introduced to the Senate on March 9th, 2017. This is not a direct result from the Oklahoma home invasion scenario, which we covered last week. But we will draw correlations between the two. First of all, let's dive into this a little bit. Okay, removes provisions that provide immunity from civil liability and actions involving use of force under certain circumstances. So currently the self-defense laws, and this is covered by NavadaCarry.org, and there are links from this page to the actual legislative information which you can delve into yourself. So justifiable homicide. Justifiable homicide is basically what is justifiable in killing another person, the criteria that are outlined at least for the state of Nevada. That means justifiably killing somebody in defense of your person, of your habitation, of your vehicle, or against any other, innocent person involved in the scenario. Okay, and this is important, number 2, a person is not required to retreat before using deadly force as provided in subsection 1 if the person, these are the guidelines here, A, is not the original aggressor, okay? B, has a right to be present at the location where deadly force is used, and C, is not actively engaged in conduct and furtherance of the criminal activity at the time deadly force is used. It then moves on to cover that there must be a reasonable fear required, so that the person had to have acted in basically the justifiable homicide and killing the perpetrator strictly out of fear. They fired shots or stabbed or harmed or killed the other person because they were in fear of their life or, loss of property. It cannot be a result of revenge or any other type of circumstance where the situation is diffused and then the threat is gone and then the person then, would follow them and shoot them or do whatever. Once the fear essentially is extinguished, there goes your right to be able to justifiably kill another person. Most of these laws, as they apply in most states, of course, because they give you immunity in terms of any type of criminal charges that can be placed against you if you are acting in accordance with the stand your ground doctrine in your state. Usually that carries with it civil immunity, civil lawsuit immunity, which basically means if the state cannot find you guilty of committing a felony or a crime in shooting the person, the state also says that the perpetrator themselves, should they survive, or any family, cannot sue you in civil court for monetary damages, which makes a lot of sense. It would be a backwards judiciary system which would allow laws to say that you are not criminally responsible for a crime, but you are civilly responsible for a crime, and therefore you owe a lot of money in your livelihood to the parents or whoever of the person who was killed, who was trying to attack you and kill you or rob you. But yeah, that would be backwards inter Nevada. So let's take a look at the senators who are trying to push this bill into effect. We have Senator Aaron Ford, Democrat, Senator Kelvin Atkinson, Democrat, Senator Pat Spearman, Democrat, Senator Mo Dennis, Democrat, Senator Yvonne Democrat, Assemblyman Jason, and I'm going to spare you a little bit of a, suspense. They're all Democrats. Not surprising. Basically what we are starting to see, and this is kind of boiling down into two things. Back at the end of 2015 into 2016, there were a bunch of articles put out I have one here by NBC News, and the title says it all. With Washington stymied, it's up to the states to pass gun reform. We have been seeing this continually back during the Obama administration. There were a lot of anti-gun legislative actions proposed, which all subsequently pretty much failed. So we saw a lot of anti-gun groups pushing the states to pass their own laws. We've seen this in California, we've seen this in Colorado, we've seen this in Connecticut and New Hampshire. It's kind of happening everywhere, it almost seems like. So, and unfortunately, the gun control advocates are actually having a lot of success on the state level passing these measures. This is something that follows on with that, and in which case you say, well, revisions to a stand your ground law, how is it really attacking gun rights and gun ownership? Well, what it does is, what good is your firearm if you're purchasing it for self-defense? When in the commission of a crime, you have to stop, and as a citizen of Nevada, if this were to pass, you would, if somebody's breaking into your home, and again, this says under certain circumstances this would apply, and I don't know what those are, you are now within the lines of a box where you're making a decision that says, if this person is breaking into my home and they are not necessarily here to kill me, they're unarmed, they just want my TV set. Hell, let's even say, okay, they have a three-year-old kid at home and they can't even afford to feed them because they lost their job or something happened, and they really are there not to cause you any harm. They didn't know you were home, but you happen to be home, and then you draw your weapon and you shoot them. You could, potentially, open yourself up to a civil lawsuit where the person could then, that person, if you don't kill them, could sue you, or their family could sue you for basically damages. And there are no real caps to tort law, and this would fall under tort law. I'm not an attorney, by the way. I tried, that's probably very clear. So tort law mainly deals in civil dispute. Keep in mind, civil law, which pertains to this, and criminal law are two completely different things. Criminal law, your punishment is serving time in a prison, essentially, or probation, or something like that. So in a civil proceeding, what you're actually going after is monetary gains from the defendant in the case, which means that if the family member or whoever wants to sue you, they're going after your money, not necessarily your freedom. So again, state can't touch you for criminal damages, family of the felon can for money. Bringing this back full circle, sorry to go off on a tangent, now the person has to deal with the fact that that person's breaking into their home. They don't know necessarily why they're there. So they could wait to make sure that there's an imminent threat and then shoot and potentially lose their lives in doing so. Or they don't wait until there's an imminent threat and shoot the person merely for breaking into their home. Or they could face, open themselves up to a civil dispute or being liable to pay the family millions and millions and millions of dollars. So you're kind of damned if you do and damned if you don't. And that is what is so draconian about this whole thing. It just boggles the mind. There is yet another angle to this, and I'm going to go a little bit conspiracy theory. Not really so much conspiracy theory, but we have the gun control measure, which of course I think we can all see that. The second side of things, and this is typical when you're talking about civil or tort law, is you do have organizations, a bar of lawyers, who love these types of laws. Why do they love these laws? Let me give you an example. If somebody were to break into your home and you shoot them, and then now, because of this law or this bill, they have grounds to sue you for all their medical expenses, because after all, they weren't armed, they weren't intending to do you any harm, they just happened to break in to get drug money or whatever, feed their kids, I don't know, it doesn't really matter. And then you shoot them, and now they're in the hospital with a $300,000 medical bill, pain and suffering, lost wages, anything that they want to get you for. Now their attorneys can basically say, we have grounds to sue, and we're going to sue them because what's happening is if you are sued and they win, it's your homeowner's insurance that's going to pay out the premium. If you're not a multimillionaire and if you don't have hundreds of thousands of dollars, it doesn't matter because they can go after your insurance. Not only are you, the homeowner who has defended themselves, going to have to fight the battle in a civil lawsuit, which could take you years, your own attorney a lot of your time. If you kill the person, then that's extra time. You're going to have to keep that kind of at the tip of your mind. You're also going to have to fight your insurance company because, again, if you're facing a civil suit and you're found guilty in the civil suit, the insurance company can use that as ammo to say, you were found guilty of negligence in a civil suit, therefore we don't believe we have the reasons to have to pay you. You acted unlawfully in a civil circumstances. And that's the thing, you didn't really act unlawfully, but this civil suit, you were found guilty, you owe the plaintiffs a bunch of money. Therefore, if you're found guilty, then you're guilty of acting irresponsibly, therefore we're not paying your premiums. So there's that double-edged sword. However, if the insurance company does pay out, what that does is a law like this gives a direct pipeline from the attorney's office all the way until your insurance company. I mean, that's just an extra huge amount of resources for attorneys in Nevada to use to hire clients who are hurt committing crimes to get a lot of money from your insurance company. So delving into this a little bit more, here is the ATRA from atra.org. Basically, they have, since 1986, they are the only national organization exclusively dedicated to reforming the civil justice system. It is a nationwide network of state-based liability reform coalitions backed by 135,000 grassroots supporters. ATRA also has an unparalleled track record of legislative success. What does that mean? What is liability reform and tort reform? It's basically saying, since tort laws and civil disputes, this is an organization that aims to put caps on the amount of money that a person can make off of you if they sue you in a civil dispute based on what the claim is. Typically, you see this in medical malpractice claims. You see this, for example, if somebody's jogging outside and they happen to pass through your front yard and they trip on a stone and break their ankle, they could technically, and they could win if they find you negligent for digging a hole or something there, I don't know. That person could sue you for their medical damages for being on your lawn. They could also try and go after you for wages lost if they're out of work for a month. They could try and get you for punitive damages if they think that you are irresponsible and negligent and that's why they hurt themselves. They can try and get you for any array of things. Now, what an organization like this does is to say put a cap on really how much, if somebody's running through your yard and they break their ankle, really how much can that person really make off of you? In states where there are very little tort restrictions or caps, if the sky is the limit, somebody could be running through your yard, trip, break their ankle, and sue you for $10 billion. So without these types of laws, it does protect people who might be sued in frivolous lawsuits. So if we look at the western side of the country, Nevada actually has the lowest number of tort reforms, second only to New Mexico, but we all know why New Mexico is the lowest. I think if you look in the entire country, they're ranked at something like number 10 from the bottom. You have states like Florida, 54 tort reforms, Arizona, 34, Oklahoma, 89. Nevada has a total of 11. So if we go and look at those 11, a lot of them are rooted in medical malpractice claims. So there is a lot of defense for the medical industry there. But in Nevada, attorneys there pretty much have a heyday because when they do, trial attorneys, when they do take their client and to pursue a defendant in a civil lawsuit, there really are not a whole lot of caps put on things, which means, hand in hand with this law, if it were to pass and somebody were to sue you because you're in Nevada and you shoot somebody for defending yourself, not only can they sue you, but there's no tort reform. There's really not a whole lot of limits that can be put on how much you're going to owe. They can pile on and pile on and pile on, and if a judge finds you responsible, the attorney is going to take their 40 or 50% commission of some massive number, which hopefully would come out of your homeowner's insurance, and best case, maybe your premiums go way up. Worst case, your homeowner's insurance, the liability coverage doesn't cover you, and then you have to be indebted for the rest of your life and probably file for bankruptcy. That is the position that they're putting you in. What this does, SB254, is it allows the criminal to become the victim. The criminal who broke into your home the criminal who tried to steal your things or damage your property or hurt you or hurt your family, they now have a leg to stand on when you defend yourself, or their families now have a leg to stand on when you defend yourself, to basically take you for everything you have. One final thought, and then I'll wrap this up. I've been rambling a whole lot, but we went back and we looked at the Oklahoma home invasion. The grandfather of one of the deceased intruders has stated it over and over. He believes that it was an unfair use of force for the person to use an AR-15 to defend themselves. There should be laws that limit the use of force when used to defend oneself in their own home, even if the person is an imminent threat. That homeowner didn't believe he was in danger. He was in danger. The people were breaking into his home wielding weapons. He was in danger. This person, and I'm sorry, but I mean, this completely delusional, let's place the blame on everybody but me person, this person would take that 23-year-old to court. If you guys have any questions, please leave those down in the comment section. Please like and subscribe if you enjoyed this video and want to see more. Again, this is Chris with Marksman Shooting Sports in Westfield, Indiana. You are watching Marksman TV. We will see you next time.